I thank the nominees for being here and their families for offering them up and their service to their country, both family and nominees. The National Labor Relations Board, or the NLRB, is tasked with resolving labor disputes and protecting workers' rights under federal law. Under the Biden administration, the NLRB weaponized its authority against workers. It overturned decades of NLRB precedent, created instability for workers and the nation's economy. We now have the opportunity to restore stability by providing the board with a quorum so that it can clear the backlog of cases left unresolved by the previous administration. By the way, Democratic-led states like New York have used the lack of a quorum as an excuse to unconstitutionally seize NLRB's authority, undermining workers' ability to organize and file claims when rights are violated. President Trump is focused on delivering the most pro-worker administration in history, and to do this, he needs board members who are fair and who put American workers first. The NLRB nominees before us today are aligned in the president's vision. We'll be hearing from Mr. Jim Murphy, who brings decades of legal experience at the NLRB, including as former chief counsel to 3 former board members. His strong record shows a commitment to upholding labor law and creating stability for both workers and employees. The fact that he came out of this in retirement shows that the old adage that you get married and you can, how's it go? For better or for worse, but not home for lunch, that clearly his wife didn't want him at home for lunch. So anyway, thank you, family, for offering up Jim. The committee will also be considering Mr. Scott Mayer for his second NLRB seat, for the second one. For decades, Mr. Mayer has worked to negotiate fair contracts between businesses and labor unions. This expertise will be crucial as the administration looks to realign the board to prioritize workers' rights. Beyond the NLRB, we'll also hear from Rosario Palmieri, nominated to be the Assistant Secretary for Policy at the Department of Labor. Mr. Palmieri brings extensive experience in federal policy, including at the Office of Management and Budget and multiple congressional committees. He's committed to working with Congress to modernize DOL, including to create greater flexibility for states to administer workforce programs. Thank you all for being here. Again, thanks to family for the support you give to these nominees. With that, I recognize Senator Sanders.
Thank you, Mr. Chairman. This morning, we'll be considering 3 of President Trump's nominees, Rosario Palmary to be Assistant Secretary of Labor, James Murphy to be a member of the NLRB, and Scott Mayer to be another member of the NLRB. Mr. Chairman, I am opposed to all of these nominations, but before we get there, there is some good news, and that is, as you know, last night the nomination of E.J. Antoni to be Commissioner of the Bureau of Labor Statistics was withdrawn. And that is a very good thing because Mr. Antoni was eminently unqualified for the job. So I hope that the next nominee will be somebody who will bring forth statistics and information that the American people and policy makers can trust. It is no secret today that we are living in a nation of more income and wealth inequality than any time in the history of the country. It's no secret that the people on top have never, ever had it so good, where you have one person owning more wealth than the bottom 52% of American households. And while the very richest people in America become richer, 60% of our people are struggling paycheck to paycheck. They're worrying how they're going to pay for their groceries, worrying how they're going to pay for health care, worrying how to pay for education. Housing situation is a disaster. So you got a nation in which some people are doing phenomenally well. The average worker is struggling. One of the ways that workers can improve their standard of living is by organizing into unions. Organized labor, people who are in unions, earn substantially more than non-union workers. They have better benefits, they have better working conditions, which is why when I was chair of this committee, we worked very hard to pass the PRO Act, which would make it easier for workers to join unions. Unfortunately, we were not successful in doing that. Now, today, among the applicants, the nominees in front of us, we have a gentleman named Mr. Mayer. Mr. Mayer, thanks very much for being with us, who has been the chief labor counsel at Boeing, a position he still holds today, as I understand it. It just so happens, really quite coincidentally, that last night on a Zoom call, I spoke with some 460 workers at Boeing in St. Louis, Missouri, who have been out on strike against Boeing for 9 weeks. And what they told me was really quite shocking, and I'll look forward to Mr. Mayor commenting on that in a moment. These workers, who are extremely skilled workers, who manufacture state-of-the-art fighter planes, the best aircraft in the world, in some cases make as little as $18 an hour, and many of them went on strike because they were sick and tired of needing to work 2 or 3 jobs just to make ends meet. Meanwhile, you have a company in which just recently could afford to pay its CEO, Mr. Ortberg, $18 million for 4 months' work. 4 months' work. It is a company which had enough money to provide a $45 million golden parachute to its former CEO, Dennis Calhoun, who did not do a particularly good job. 5 years ago, Boeing had enough money to provide the CEO, before that, Mr. Muhlenberg, with a $62 million golden parachute. So, Mr. Chairman, that's kind of the world that we live in today. You're a CEO, and some of these CEOs, we all know the story of Boeing having some problems, don't do a particularly good job, you got huge golden parachutes. You're a worker, you have to work 2 or 3 jobs. And by the way, maybe Mr. Mayor will explain to us why the health care of these workers in St. Louis was taken away. I don't know how a working person survives. They have kids, wives who are ill, how they survive without health care. So that's an example of the kind of member of the NLRB that President Trump is nominating. It's certainly somebody who and I would not be sympathetic to. So thank you very much, Mr. Chairman.
So I'll introduce the nominees as each of them is their turn to speak. We'll start with Scott Mayer, President Trump's nominee for the member of the National Labor Relations Board. Mr. Mayer brings on-the-ground experience to the board from a career spent at the negotiating table. His stated focus will be producing stability and predictability in board decisions, which has been sorely lacking. He's a graduate of the School of Industrial and Labor Relations at Cornell University, earned a JD from Villanova. I look forward to hearing from you today, sir. Thank you for joining.
Thank you.
Will you turn on your microphone?
Oh, I think I did.
May I need to pull it closer to you.
Chairman Cassidy, Ranking Member Sanders, and other committee members, thank you for the opportunity to testify today. I also want to recognize and thank President Trump for this nomination. It is the ultimate honor and certainly the pinnacle of my career as a labor attorney. My wife of 21 years, Lori, is seated behind me. My teenage children, Haley and Ben, are not here today as they're in school. I'm sure the Help Committee supports their focus on education. Unfortunately, my father cannot join us today for medical reasons. My family has always supported my public service and would be proud to support my continued public service if I'm confirmed. I want to start by saying that I believe in the National Labor Relations Act. The National Labor Relations Board, which I've had the pleasure of working with for the last 27 years, impacts nearly all private sector employees, large and small employers, and unions across the country. The NLRB as an institution is important and has a profound impact on all stakeholders. The work done by both the board in adjudicating cases and by the general counsel in the regions is critical for maintaining productive labor management relations while setting rules for employers, unions, and employees. Labor has impacted my entire life. My grandfather was a union sheet metal worker in New York City. My father was a journeyman electrician and proud member of the IBEW Local 3, and my late mother was an elementary school teacher in Newark, New Jersey, represented by the Newark Teachers Union. Growing up, my father would occasionally take me to his work sites, and I even attended the Local 3 summer camp on Long Island, where I once met Harry Van Arsdale, Jr., a titan of New York City labor. As a senior in high school, I won a Local 3 scholarship to study labor at Cornell University's School of Industrial and Labor Relations. While in college, I interned for the New York State Nurses Association, where I not only performed research for the association, but also helped with organizing. I recognize and appreciate what labor has done for workers, for my family, and for me. This background has guided my balanced view of the law and how I approach my practice. After Cornell, I attended Villanova Law School, where I focused on labor and employment law, including an externship with the NLRB in Philadelphia. After I received my law degree from Villanova, I practiced labor and employment law at Blank Rome in Philadelphia, where I spent most of my time handling arbitrations, labor negotiations, litigation, and compliance training. I learned a valuable lesson right away. Most companies want to treat their employees well and comply with the law. Just before my son was born, I left law firm life and began working in-house for Aramark in Philadelphia, focusing my practice exclusively on compliance with the National Labor Relations Act. With its hundreds of collective bargaining agreements, my time at Aramark allowed me to tackle a broad array of labor issues, from bargaining obligations and successorship compliance to dealing with union trust fund issues and unfair labor practices. It's here I learned the importance of finding common ground with labor unions. Around 15 years ago, I became an active participant in the ABA's Committee on Practice and Procedure under the NLRA. This committee is unique insofar as its actions require consensus by labor and management. I've met and worked with highly skilled management and union side practitioners, had spirited discussions, and had success in finding common ground. The essence of labor relations encourages creativity, respect, and cooperation, all skills I developed throughout my career. I spent 10 years at Aramark. Since then, I've had the privilege of working for a law firm and a few companies, expanding my experience to include multiple industries. And for the last 3 years, I've served as Chief Labor Counsel for the Boeing Company. In total, I've spent decades helping my various employers comply with the law. Finally, I believe strongly in public service. I've served as a member of my local school board for the last 15 years, including a 3-year period as board president. I worked alongside amazing professionals on the board and in the school district administration. I especially love working with our teachers, carrying on my mother's legacy. During my time on the school board, we improved our relationship with our teachers union. This position taught me many lessons about leadership, the importance of public service, and listening to varying points of view. It also gave me one of my greatest personal moments, handing my daughter her diploma last year. If confirmed, I commit to the following principles. First, I'll consider every case based on the facts presented. Second, I'm a steward of the labor law policies originating within Congress, and I will follow those laws. Third, I'll seek to achieve compromise with a goal of stability for all stakeholders. Most employers simply want to know the rules and comply with the rules. Our goal should be to create stability in how the NLRA is interpreted and applied. Finally, I'll rely on and respect the hardworking career professionals and staff members at the NLRB who work so hard behind the scenes to serve the public. It's an honor and a privilege to be here, and I look forward to the committee's questions. Thank you.
Thank you, sir. Next is James Murphy, President Trump's nominee, again for member of the National Labor Relations Board. He brings decades of experience at the board where he has consistently demonstrated faithfulness to the letter of the law, serving as chief counsel. His long tenure means he's well-positioned to help the board address its backlog and work to resolve workers' cases. He's a graduate of Princeton, earned his JD from the Washington College of Law at American University. Thank you, sir. Please.
Chairman Cassidy, Ranking Member Sanders, and other committee members, thank you for the opportunity to testify today. It is an honor to be here, and it is an honor to have been nominated by President Trump to be a member of the National Labor Relations Board, the agency I worked for throughout my entire professional career. With me today is Karen Murphy, my wife, partner, and best friend for over 53 years. Karen and I have 3 adult children, Sean, Colleen, and Brendan, as well as 4 grandchildren, Sean's sons Sterling and Tucker Maverick, and Brendan's twins, Ariston and Jameson. Colleen is here today, as is Sean, with his sons, who are taking time off from school for a civics lesson. Government service is a common feature of the Murphy family history. My great-grandfather, Daniel Murphy, an Irish immigrant, worked as a laborer and mason on the Massachusetts State Hoosac Tunnel project in the mid-1800s. His youngest son, my grandfather Benjamin Murphy, was among the first employees working for the new Internal Revenue Service in 1917. Both of his sons served in the military during World War II. Daniel Murphy, my dad, was in an armored tank company in the Philippines in 1945. His brother and my namesake, James Murphy, became an Army bomber co-pilot. His first and only combat mission was a bombing run to Germany in April of 1945. Returning from that mission, another bomber in the squadron collided with his. Both planes went down into the North Sea, and all crew were lost. Last, but certainly not least, my mother, Elizabeth Cry Murphy, was among the thousands of young women who came to Washington in the 1930s to work in the newly expanded federal government. In 1941, she went to Honolulu to work for a federal contractor. On December 7th of that year, she and her roommates heard the planes fly over and heard the bombs drop. Later in 1944, she went overseas to work for the War Department, first in Algiers and then in Naples. My opportunity for government service came late in my first year of law school when board member John Pinello, a family friend and neighbor, asked if I would be interested in working on his staff as a summer intern. Doc, everyone called him Doc, was among the first employees of the NLRB starting in 1937. I readily accepted his job offer in 1974, continued to work on his staff on a part-time basis during the next school years. When I graduated in 1976, Doc hired me as a full-time staff attorney. He went into private practice in 1981. I continued to work on one board staff or another, progressing from staff attorney to staff supervisor to independent senior counsel, and finally to staff chief counsel for a succession of board members from 2008 until I retired at the end of December 2021. Taken together, the period served by Member Pinello and myself covers almost all of the board's 90-year history. Throughout my 47 years of board service, I was constantly impressed with the dedication, intelligence, and diligence of the employees I worked with, regardless of whether we agreed on any particular policy issue. They and I shared a common goal of resolving the many unfairly practiced and representation cases before us as expeditiously as possible. That is or should be a nonpartisan goal. The public we serve should expect no less of the board. Unfortunately, for various reasons, the board has at times fallen far short of meeting that goal, with the result that employees, employers, and unions have in many cases had to wait years for final resolution of the case. By that time, the real resolution has been determined by the delay, rather than by the administrative decision finally announced. I have been quite content in retirement. Under different circumstances, I would have declined the unexpected invitation to return to work as a board member. Frankly, an interest in addressing current policy issues, as important as those issues are, would not alone have drawn me back. My paramount concern and the motivating reason for this undertaking is the need to reinvigorate the agency's case handling process in order to address a pending caseload backlog that has significantly increased since 2021. If I am confirmed as a board member, I pledge to uphold the act, to give fair and impartial consideration to every case brought before us, and to reach final decision in each case in time to give real meaning to the parties involved. To do otherwise would, in my opinion, be a violation of my oath of office. Thank you for the opportunity to offer these opening remarks, and I welcome your questions.
Thank you. Next is finally, we're joined today by Rosario Palmary, President Trump's nominee for Assistant Secretary of Policy for the Department of Labor. Mr. Palmieri served at the Office of Information and Regulatory Affairs under the first Trump administration. His experience will help the Department of Labor implement President Trump's pro-worker agenda. He attended American University before receiving his JD from American's Washington College of Law. American's Washington College is well represented today. Thank you, sir. I look forward to hearing from you.
Thank you very much, Mr. Chairman, Ranking Member Sanders, and members of the committee. It's an honor to appear before you today as President Trump's nominee to be the Assistant Secretary for Policy at the Department of Labor. I'm deeply grateful to the President for this extraordinary opportunity and for the trust in my ability to serve the American people. Before I begin, I want to thank the people who have supported me and who inspire me every day. My mother, father, stepmother, stepfather, and my brothers and sisters are a constant source of strength and encouragement. I would not be here today without their love and support. I especially want to thank my father, who's here with me today. He's taught me so much about being an ethical man and has role modeled how to be an ethical and excellent employer of many workers over the course of his career and many small businesses. I also want to thank my friends and colleagues who are joining me here today, as well as those who are watching online, both my colleagues at OMB OIRA and the incredible career staff that I've had the opportunity to work with this year, as well as in my past service. My passion for public service and my commitment to the American worker are rooted in my family story. My parents, who never had the opportunity to attend college, worked tirelessly to ensure their children were afforded the opportunity of an advanced education. My family members have pursued careers as entrepreneurs in healthcare, research, and hospitality, demonstrating the varied paths to the American dream that they've pursued. I am named for my great-grandfather, Rosario, who came to this country from Italy in the early 20th century. He was a proud Italian immigrant who built a life for his family with his own two hands, working in construction and manufacturing before he saved enough to open his own small business, a grocery store. His relentless hard work and entrepreneurial spirit taught our family that with grit and determination, the American dream is within reach for everyone. My other great-grandfather, William, came to this country from Ireland and settled in western Pennsylvania. He worked in a coal mine and later worked in the steel mills of Pittsburgh, the city where I grew up. My hometown's history is inextricably linked to manufacturing and industry, and because of this, the strength and security of the American worker have always been a part of my story. These men worked in the very industries that have been the backbone of our economy. They were the wage earners and job seekers the Department of Labor was created to serve. Their experiences, from the demanding work of coal and steel to the promise of owning a small business, have given me a personal understanding of the challenges and opportunities facing our workforce today. This background, combined with more than 2 decades of professional experience in both the nonprofit sector and government, has prepared me for this role. For more than 15 years, I served manufacturers as a leader in trade associations where I worked to advance American manufacturing. My legal training, combined with my experience in regulatory policy, both at OIRA and in OMB, have given me a deep appreciation for the Office of Policy's vital role as the department's central hub for evidence-based policymaking and for managing its regulatory portfolio. I understand the work of the U.S. Congress, having previously served as staff on committees in the U.S. House of Representatives, where I had the opportunity to conduct oversight of regulatory agencies and their impact on manufacturers and small businesses. Throughout my career, I have dedicated myself to understanding the relationship between workers, employers, and government, and I've worked to build consensus and deliver results. I believe, as does Secretary of Labor, that the federal government's priority must be to put the American worker first. If confirmed, my guiding principle will be to serve the American workforce by ensuring a level playing field so that everyone has a fair shot at a family-sustaining career. I promise that my door will always be open. My goal is to work with the incredible team at the Department of Labor to support a resilient and prosperous American economy for generations to come. I thank the committee for the opportunity to appear before you today, and I look forward to your questions.
Thank you. I'm here for the duration, so I will defer to Senator Houston so he can.
Thank you, Mr. Chairman. Mr. Murphy, first of all of you, thank you for being here today, and congratulations on your nominations. Mr. Murphy, thank you. I want to share, first of all, a thought that while there are a few things that are universally true in a public service setting, I've always said that give me a quick yes or no, but a long maybe is the worst. And as I look at the, you have experience at the NLRB, and as I look at the case backlog in the day, and you referenced this in your testimony, that it's increased to an average of 154 days. And what do you attribute that to? How do we fix it?
There are multiple causes, I suspect. One of them is there was a substantial, is it on?
Yeah, pull your microphone close.
Okay. There are multiple reasons, I suspect, for that increase. Recently, that would be the loss of a quorum for a period of time. But even predating that, during the past 4 or 5 years, there's been a substantial increase in the number of unfair labor practice charges and filed. They originate in the regional offices, but some of them do percolate up to the board. Also, the board has engaged at times in rulemaking. Rulemaking is an incredibly onerous procedure. We adjudicate most cases rather than have rulemaking, but whenever the board does decide to engage in rulemaking, that can slow down the handling of other cases. The best I can say to you as far as going forward is that we will probably have a lot of what people would refer to as low-hanging fruit available to us. And we can dispose of those cases, hopefully on a unanimous panel basis, as quickly as possible. And then we will try to address the backlog by identifying whatever cases we can move as quickly as possible, hopefully with an emphasis on the oldest pending cases.
Okay, thank you. I would encourage every effort be made to get through those as quickly as possible and give people, the services, the answers that they're seeking on these matters. Bring them to conclusion. Mr. Palmieri, in your role as Assistant Secretary, I want to talk with you about piece of legislation that I have, a bipartisan piece of legislation that would encourage or require the training of personnel to identify, help them better identify signs of human trafficking in the workplace, labor trafficking, and to help law enforcement by using the personnel at the Department of Labor to identify these cases if they see them and turn them over to law enforcement. The scourge of human trafficking, labor trafficking, is widespread in this country, and it's one of the most heartbreaking things that I think occur out there in the deep, dark places of our economy. And I just want your thoughts on, first of all, I'd love to have your support and your commitment that if we get this done, that you will make sure that this is getting implemented. And do you see this as a role that you can play at the Department of Labor?
Thank you very much for the question, Senator. Appreciate your leadership, Senator Hawley's leadership, and many other members of this committee on this critically important issue, and not just trafficking, but also the trafficking of the most vulnerable of children is just a horrific act. And I think, to your point, it's critical that the Department of Labor utilizes all of its resources to be put to the task. As I understand it, the Office of Policy helps to coordinate between the divisions and administrations within the Department of Labor to ensure that we're meeting those both statutorily required objectives, but also the objectives of this administration and the Secretary to ensure that those investigators in the field, the data that we're collecting, every piece of information and evidence that can be put to the task of taking on this challenge is used and available. And I'll certainly make the commitment, sir, if confirmed, that I'll be happy to work with you in your office to ensure that this is being addressed adequately.
Yeah, you have thousands of inspectors out there on the ground every day, inside manufacturing, inside food processing, inside hotel and leisure, restaurants, things like that, and they can be the eyes and ears to help give tips to law enforcement. As law enforcement tells us, it's very hard for them to see these things. And when they get tips, they will pull on the string and unravel the knot, but they need to have that access to that information. Department of Labor is uniquely positioned to be able to help with that. So I appreciate your help. Thank you. Thank you, Mr. Chairman.
Senator Sanders.
Let me start off with Mr. Mayor. And Mr. Mayor, in your remarks, you talked about fairness and compromise and trying to bring people together. You are now the General Chief Labor Counsel at Boeing. As you're aware, there's been a strike going on for 2 months now. And I want to get a sense from you as to about that strike, because I think it will tell us a little bit about what kind of member of the NLRB you will be. So let me start off by asking you a very simple question, and that is, do you think it's was appropriate for Boeing to pay its current CEO $18 million in compensation for 4 months of work? 4 months of work, while it at the same time eliminated the health care benefits for 3,200 machinists in St. Louis. Is that the kind of approach that you would use as a member of the NLRB?
Good morning, Senator Sanders, and thank you. Let me start out by saying that I'm not here as a representative of Boeing. I'm here to discuss my nomination. Secondly, Senator, I have not been involved in the negotiations in St. Louis. I've been specifically kept out of those negotiations because in anticipation of this process.
You are the Chief Labor Counsel
Yes,
for
Senator.
Boeing, and you have no knowledge or not been involved in the strike in St. Louis?
That's correct. We have other lawyers that are handling
Well, all right,
this matter.
but you are a high-ranking member of the Boeing Corporation. So I'm giving you information which is accurate, whether you've been involved or not. You want to be a member of the NLRB, you tell us you want to treat workers fair. Do you think it's fair that workers lose their health benefits during this strike while the CEO gets $18 million for 4 months' work? Sound fair to you?
Senator, I'm not going to comment on the compensation of other executives. I will say that there was negotiations in St. Louis. There was this is all public information. There were negotiations in St. Louis. There was an agreement reached with the union. The union hailed that agreement as a landmark agreement.
But that agreement was
and recommended
but that agreement was rejected by the workers.
The union recommended that it be ratified.
But it was rejected by the rank and file, correct?
And that's their right.
That's right. That is their right. Excuse me.
Yes, sir.
If Boeing could sign a fair contract with 32,000 machinists in the state of Washington, members of the IAM, last year, why can't, in your judgment, it sign a similar contract for 3,200, 10% of the workers, machinists in St. Louis who manufacture fighter jets for the military?
Senator, respectfully, I'm not going to get into, I'm unable to really comment on the negotiation status for our negotiation in St. Louis.
Let me ask Mr. Murphy, thank you. Let me ask Mr. Murphy and Mr. Palmieri a question, and that is SpaceX, as you know, is owned by Elon Musk, the wealthiest man in the world, and Amazon owned by Jeff Bezos. I don't know where Jeff is now, maybe second or third. He's struggling, but he's up there. They have both filed lawsuits arguing that the National Labor Relations Board is unconstitutional. In other words, you're aware of that, Mr. Murphy. Simple question. Do you believe that the NLRB is unconstitutional?
No, I do not, Senator. The Supreme Court in 1937 in Jones and Laughlin Steel found that the National Labor Relations Act was constitutional. Unless there is a definitive Supreme Court decision to the contrary, I believe that it remains constitutional. There may be constitutional infirmities that could be redressed, but that would not negate the constitutionality of the agency.
Thank you. Mr. Palmieri?
While I don't have a specific view, I would agree that it has been found constitutional in the past.
All right, let me ask you if President Trump directs you to rule in favor of Amazon or SpaceX and in opposition to the rights of their employees, would you do so?
It's a hypothetical that I hope never comes to pass, sir. I would have to contemplate all options.
The problem that we are living in is a moment where a lot of things that we didn't think would pass are passing. So I guess what I'm asking you, will you have the independence to say, sorry, Mr. President, I've got a job to do? Or will you say, yes, sir, I'll do it?
I might say, depending upon the circumstances, sir, that I question that directive and under the law that I'm obliged to apply. And if the Supreme Court holds, as it apparently would on a procedural basis, that the president has the opportunity to remove me, then the president would have that option.
Okay, thank you.
Senator Hawley.
Thank you very much, Mr. Chairman. Congratulations to all the nominees. Thank you for being here. Mr. Mayor, let me start with you. I represent the state of Missouri here in the Senate. In Missouri, in the city of St. Louis, there are 3,200 machinists, a little bit more, who are currently on strike. The overwhelming majority of these folks are Missouri residents. They're striking against your company. You're the chief labor counsel. What do you think the fair outcome to this dispute ought to be?
Thank you, Senator, and good morning. Let me start by saying I'm not here as a representative of Boeing.
But you're employed by Boeing.
Yes, sir.
How many years have you been employed by Boeing?
Just over 3 years, sir.
Mr. Mayor, is your microphone on? If so, could you pull it a little bit closer?
Sorry, my first time here. I've been with the company about 3 years.
So my question is what do you think is a fair resolution to this dispute? I mean, we've got 3,000 plus Missourians who are currently effectively out of a job. They haven't had a significant wage increase in years. They need to be able to afford to pay rent, to put food on the table for their families, get their health care. I mean, is your company going to do right by these workers? You can understand why I have a I've got a significant interest in this. This matters a lot for my state. It matters a lot for these workers and their families. There's a lot of people.
Certainly, Senator, I agree. It matters a lot. It matters to our hardworking employees, our hardworking the members of the IAM. I know, the concept of fairness is an elusive one. What I will tell you is that the union and the company reached an agreement at the end of July. I'm not, as I said earlier, I'm not involved in that negotiation.
Well, I mean, is the concept of fairness you say is elusive? Let me ask you this. In 2024, David Calhoun, that wasn't a question, I'm just quoting you. In 2024, David Calhoun, who's your executive at the time, got $32.8 million in compensation in a year. $32.8 million. That was a 45% increase over the previous year. At that point in time, your planes were literally falling out of the sky in pieces, and you weren't paying your workers. Is that fair?
Senator, I'm not in a position to comment on executive compensation.
Well, you're the chief labor counsel.
I am the chief labor counsel.
Were you involved in the settling the machinist strike in Seattle, I think it was?
Yes, Senator, I was involved in that negotiation.
Okay. Do you remember what the contract was you finally gave the Seattle machinists?
I remember parts of it. I can't.
Wage increase, 38% general wage increase over 4 years, plus the option of a $12,000 one-time ratification bonus or a $7,000 ratification bonus and a $5,000 401k contribution. Does that sound roughly correct?
That sounds roughly correct.
Okay. Why wouldn't you just do that for the folks in St. Louis?
Senator, every negotiation is different.
Well, plainly so, because what you're offering to my constituents is a fraction of that, and I guess I just don't understand why. I mean, is it that what's different about the folks in Missouri?
It's not a question of difference about the folks in Missouri. It's a question about.
You just said a minute ago, fairness is elusive. I mean, it does seem to be elusive for the Missouri strikers.
Senator, fairness is a matter of what the parties ultimately agree to. Again, as I stated earlier, the union and the company came to reach an agreement. The union felt that the agreement that we reached at the end of July, and
which the workers didn't ratify, right?
This is all public.
So here's what you've offered currently. You've offered Missouri workers a wage increase that's 16% below what you offered the Seattle workers. You're offering them bonuses that are thousands of dollars below, $8,000 or $10,000 less. With far fewer other benefits. I guess I just don't understand. I mean, what's different about these Missouri workers? I mean, there's only 3,000 of them, although that's a lot of people. It was 33,000 in Seattle. How is this going to end? Are we going to get to a fair resolution here where these workers get paid on terms equal with other workers at your company across the country? Or are these folks going to be permanently replaced by non-union workers?
Senator, there was an offer on the table. The employees voted it down, as you stated.
Right. That was months ago. I'm asking about now. What's going to happen going forward?
The employees are engaging in protected activity of striking, and ultimately the parties will negotiate a deal. I don't know how it's going to end. I'm not.
Do you think it would be fair for the Missouri workers to be paid what the Seattle workers are paid?
Senator, there are a number of factors that come into play with how employees are paid and the general.
My time has expired, Mr. Mayor. I'll have more questions for you. I have to tell you, with 3,000 plus members of residents in my state on strike, unable to work, unable to get health care, while your CEO is getting paid $30-some million, that fairness may be elusive, but that doesn't look like fairness to me. Thank you, Mr. Chairman.
Thank you, Senator Hawley, and now Senator Hassan.
Thank you, Chair Cassidy and Ranking Member Sanders, for having this hearing. Thank you to the witnesses, not only for being here, but for your willingness to serve, and congratulations to you and your families. Before I get into my questions, I want to take a moment to address the federal government shutdown. While the topic of today's hearing is really important, right now Congress should be focused on working together to find a bipartisan path to reopen the federal government, restore critical services for people, and prevent healthcare premiums from doubling and keep millions of people from losing their healthcare coverage. And so while I look forward to hear more from our witnesses, I once again urge all of my colleagues to come together on a bipartisan basis to get this done for the American people. To all of the nominees, I'm going to start with a basic question, and we'll start with you, Mr. Meyer, and go right down the line. Here's the question that I have, and it's related to recent events. If directed by the President to take an action that would break the law, would you follow the law or follow the President's directive? Mr. Mayor.
Thank you, and good morning, Senator. I do not believe the President would require me or advise me to break the law, but I will always follow the law.
Thank you. I will suggest that you look at any number of the President's actions over the last few days, let alone the last 200-plus days he's been in office, and you might revise the first part of your answer. Mr. Murphy.
I agree with Mr. Mayor's remarks, but even if we received that, I would always apply the law. I would follow the law.
Thank you, Mr. Palmieri.
Thank you, Senator. Again, I don't believe the President would ask such a thing of me, but I will follow the law.
Thank you for your commitment to the law. Again, going right down the line, does following the law mean following what a court interprets the law to be, or is it whatever the President believes it to be? Mr. Mayor.
Well, the National Labor Relations Act has a long tradition of its own law. It follows.
Just generally, does the Chief Executive of the United States, does the Constitution say that the Chief Executive of the United States, the President, gets to decide what the law is, or does the Constitution say that there's a separate branch of government, the court system, the judicial system, that defines the law? What's the answer?
Well, ultimately, the Supreme Court decides what's the law.
Mr. Murphy.
That is correct. Excuse me. That is correct. It would be a Supreme Court decision.
And Mr. Palmieri.
The Supreme Court decides the law, but I will seek the advice of the Solicitor of Labor and any question I may have about the law.
Well, thank you for that. I will also suggest to you that in cases that don't go up to the Supreme Court, the courts actually have the final say, depending on where the litigation or the matter stops. To Mr. Murphy and Mr. Mayor, to my earlier point, in January, President Trump illegally removed NLRB board member Gwen Wilcox from her position on the board. Do you agree with the President's illegal action? Mr. Murphy first.
Respectfully, Senator, I think that's a determination that's going to be made by the judiciary and probably by the Supreme Court. The Supreme Court's already indicated in a procedural ruling what they would do, but I have no independent.
Mr. Mayor.
I have no independent reason to know why the President removed former Chairman Wilcox, but that issue is being litigated right now.
So let's be clear. We're members of Congress here. We write laws. And in order for them to become law, they obviously need to get a majority in the Senate. They need to overcome a filibuster in most cases. But we write the laws, and they're supposed to be followed by the executive branch, by members of the NLRB, by officials at the Department of Labor. And the National Labor Relations Act, which was written by this body, clearly states that a board member cannot be removed except for neglect of duty or malfeasance in office. Do you agree with that standard? Do you agree that that's the law that is supposed to be followed? Mr. Mayor?
Senator, I agree that's what the law states. I know that President Trump has taken action.
With absolutely, I believe his rationale is simply she was appointed by the wrong political party. Mr. Murphy?
I'm not sure what his rationale was. It was a very, very summary statement, but his position is that he can just fire her at will, regardless of the reason. And
that contravenes the clear language that I just read to you.
Unless interpreted by the Supreme Court otherwise, and that's what we're waiting to find out.
So just, Mr. Chair, for one last second, I'll submit my third question to Mr. Palmieri about the decline in manufacturing and what he would do to rebuild it for the record. But let's just be very clear. You all just told me you can't imagine the President of the United States directing you to do something that would violate the law, and yet you've just conceded that his firing of Gwen Wilcox appears to have done that. Thank you, Mr. Chair.
Senator Baldwin.
Thank you. Mr. Palmieri, the nation's healthcare workers face very challenging working conditions that are exacerbated by instances of workplace violence. The American Hospital Association released a report that states hospitals spent more than $18 billion in 2023 on costs associated with managing workplace violence. $14 billion of which were post-event costs like healthcare, infrastructure repairs, and staff productivity losses. If you're confirmed, you will oversee the Department of Labor's rulemaking process. In August, the workplace violence prevention rule was downgraded from the proposed rule stage to what they call long-term actions, often known as rulemaking purgatory. My Workplace Violence Prevention for Healthcare and Social Service Workers Act would address the issue through Congress. But in the meantime, the department needs to put forward this proposed rule. Do I have your commitment to getting this proposed rule issued and finalized as soon as you're confirmed?
Thank you, Senator. Long-term actions on the unified agenda don't necessarily signal a lack of prioritization. It may literally be related to timing. Generally, the items on the active part of the agenda are those that an administration believes can be completed in the next 12
I have your commitment
months.
to prioritize this rulemaking process. Workplace violence is a huge issue for healthcare workers and social workers.
While I'm not at the department, if confirmed, I'd be happy to work with you and your office and team and communicate with the secretary, the deputy secretary, obviously the administrator of OSHA if confirmed, and others who will be involved in that decision.
I would hope this would be an enormous priority for the Department of Labor, given the violence that is faced routinely these days, sadly, by healthcare workers and social workers. Mr. Mayor and Mr. Murphy, the NLRB is the sole agency that can conduct and certify union elections. Unless an employer voluntarily recognizes a union, this is the only way to form one. And the right of workers to organize depends upon NLRB's ability to function. In 2024, nearly 16 million workers joined a union. During 2024, the fiscal year, the NLRB received nearly 25,000 cases nationwide, the highest number in 15 years. But NLRB staffing levels have drastically reduced over the last decade and a half, and NLRB has lost nearly 40% of its field enforcement staff. Processing time for cases pertaining to unfair labor practices has exploded from a few months to well over a year. And these cases are mostly brought forth by workers whose rights may have been violated, and they deserve attention. So my questions for each of you, do you think that the NLRB needs increased funding and staff to protect workers and enforce labor laws and fully do its job? Mr. Mayor?
Thank you, Senator, and good morning.
This is a yes or no question.
Well, my answer is a little more nuanced in that I'm not in the agency yet. If confirmed, I commit to reviewing the staffing levels at the board. The general counsel's staffing and the field
Mr. Murphy?
staffing is a different story.
Your answer?
Senator, as far as fiscal year 2026, I've had no part whatsoever in the board's budget proposal and justification, and we are bound by that proposal which is under consideration by the
Would
Congress.
you commit today that you will request sufficient funding and any additional authority that may be necessary to hire and retain sufficient staff?
I think it's a very serious concern, Senator. As far as the commitment is concerned, I'll just have to see, if I'm confirmed, what the circumstances are on the ground.
Mr. Mayor?
Same answer. We will review, if confirmed, we'll review the appropriate staffing levels at the board side and on the general counsel.
More specifically, would you commit to requesting sufficient funds to keep NLRB regional offices open and accessible to the public? Mr. Mayor?
Yes, Senator, to the extent that the board side can affect that, yes.
Mr. Murphy?
The board makes periodic assessments as far as the workload and need for particular regional offices, sub-regional offices, and resident offices. I would hope we would continue to do so, and where a greater need is expressed, we would follow through.
Mr. Chairman, I ask unanimous consent to enter into the record 2 letters of opposition to Mr. Murphy and Mr. Mayer's nomination from the SEIU, which represents more than 2 million workers, and the National Nurses Union, which represents more than almost 250,000 registered nurses.
Without objection.
Thank you.
Senator Hickenlooper.
Thank you, Mr. Chair. Thanks each of you for subjecting yourselves to this this endeavor. Mr. Palmieri, let me start with you. Back when I was governor of Colorado a number of years ago, not too long ago, but a number of years ago, we worked hard to build a high-quality youth apprenticeship program that's since been expanded to probably about 20 or 22 other states. The Department of Labor's Policy Office really plays a crucial role in supporting this kind of program. So, Mr. Palmieri, if you're confirmed, how can you ensure that youth apprenticeships provide participants with strong, industry-recognized credentials, clear pathways to full employment, protective standards, safeguard young workers, and make sure that this program can be expanded?
Thank you, Senator. As you pointed out, I think your leadership on the subject in Colorado was particularly important. I think the state's and governor's support for these programs is critical. The president's announced an intention to create a million new registered apprenticeships, and as you noted, the Office of Policy, if confirmed, I'd certainly be involved in that effort to support both ETA and other parts of divisions and administrations within the department to ensure that we're not just delivering on that goal, but to your point, ensuring that industry-recognized credentials and others that are going to help people get quickly into the workforce are there. As you mentioned as well, they're important safety and security concerns, and so I'll be happy to work with your office and others to ensure that we're addressing those critical areas as well.
Great. I think it's a golden opportunity to make a giant step that could, when you look at 65 to 70% of our kids aren't going to graduate with a 4-year degree, whether we like it or not. We spent decades working on that with, only moderate success. I think that apprenticeship programs have amazing potential. I trust you'll all come in contact with it at some point. Let me go down the list of you. Mr. Mayor, we'll start with you. I'm one of the people that worries dramatically about the dislocations that are going to come as a consequence of AI. And as we look at literally every industry now trying to see how can they use AI to be more successful, not every case, but in the vast majority of cases, that's going to result in people losing their careers. And I think we've done a shoddy job of this as a country over the past 50 years. We've seen dislocations before that were not successfully addressed. Have you got any ideas about how we should think about the Department of Labor looking at as these whole professions are eliminated? How do we look at the skills? Which skills do we need to make sure that they're getting? What is the pipeline that we can guarantee and ensure that those skills are available and that the people that have been dislocated, have been lost their professions, have a real opportunity to get back on a career path?
Thank you, Senator. I'm not sure that is really within the province of the National Labor Relations Board.
I think you'll be amazed at how much of this is going to come through the NLRB. This is going to be a tidal wave everybody's going to be on board, and how we pay for it and how we plan for it is essential. And I think the NLRB is a place where, if we're not careful, it'll become a bottleneck.
The only thing I'll add, Senator, is employers relying on various tools like artificial intelligence are held to the same standards that are already set forth in the law.
Yeah, of course. I appreciate that. Mr. Murphy?
Certainly, you're correct, sir. It will be a significant issue. How it will be presented to the board remains to be seen. Right. We don't have the authority sua sponte to address an issue. It has to come to us through an unfair labor practice proceeding, or we might address it in rulemaking. But I can certainly see the job loss attributable to AI, even if it's non-discriminatory, becoming a major bargaining issue. And in that context, we make it the case.
Excellent point. Mr. Palmieri?
Thank you, Senator. As you know, the President's AI Action Plan instructs the Department of Labor to take this incredibly seriously and to direct some of the funds and resources from employee training and education to ensure that we're training the next generation of workers to be competent in AI, to be able to use these services so that they're over and above their pure labor, to be able to utilize these in ways that are going to be part of that future economy. So I know that the department takes that responsibility very seriously, and if confirmed, I know I'd spend a significant portion of my time on that as well.
I appreciate that. Whether we like it or not, this is happening in real time. I've got every one of my staff here trying to, their instructions by the end of the year is just how can AI help you be more successful? Because if you're not working with it, you're going to get left behind it. And there's one quick yes or no question for each of you. If we look back over the past 50 years, we've seen a contraction of the middle class. When you look at the percentage of representation of workers by organized labor, by unions, that's had an almost identical contraction over the last 50 years. My question is, do you think that this country is better off with better representation for workers, a higher percentage of workers having that representation, or do you think we're worse off with that? We could start with you, Mr. Mayor.
Excuse me, Senator, that's really a policy decision, and it's also a decision for for workers in each various workplace.
No, I'm just asking whether you think the country would be better off with, many decisions we make can make things go better or worse.
It depends on the types of decisions and for every company.
Okay. Mr. Murphy?
I think that's accurate, Senator, and I'm just not sure. There should be broader means, I think, for employee access to the decisional processes of employers. Right now, collective bargaining is the only possibility, but to the extent that other opportunities would arise, it would benefit everybody, company and employees, I believe.
I appreciate that. I think I'm being silenced, Mr. Palmieri. I'll get to you later.
42 seconds late.
That's their fault, not my fault.
Senator Kane.
Thank you, Mr. Chair, and thanks to the witnesses. Is it Palmieri or Palmary?
Whatever you prefer, Senator.
No, but I want to do what you want to do.
We pronounce it Palmary.
Palmieri, thank you. You referenced that your grandfather was a coal miner in Pennsylvania. Great-grandfather, I'm sorry. And I resonate with that because Virginia has a lot of coal mining communities. In fact, I was with a lot of our miners in Abingdon, Virginia, for a big event that just took place last Saturday. These miners work to keep our lights on and keep the country running, and it's led to a significant black lung epidemic in the country, which is well known. But what isn't so well known is that the black lung epidemic is particularly hard on the East Coast because of the kind of coal that's mined and the circumstances under which it's mined. A study was done between 2013 and 2017 in Southwest Virginia. My wife's family is from Southwest Virginia. Over 400 miners were identified as having progressive massive fibrosis, which is a very complicated form of black lung. It was the largest cluster ever reported in the scientific literature. And one of the things that's most concerning is the age at which people are getting this really advanced form of black lung disease is getting younger and younger and younger. So it wasn't uncommon to meet a retiree or somebody who is suffering from that. Tragic, but not uncommon. It's now more and more common to find miners in their 30s who have been diagnosed. Researchers have found that exposure to silica dust is causing severe and complicated forms of black lung disease, but also opening up people for other respiratory issues as their immunity weakens. So, for example, COVID was really bad in this part of Appalachia because people already had respiratory challenges. At many of our urging, the Mine Safety and Health Administration finalized a rule last spring to reduce miner exposure to silica dust. And the goal of the rule was to reduce respirable crystalline silica exposure, and it was projected to save 1,000 lives and prevent another 3,700 cases of silica-related illnesses. This was a long-standing effort that was undertaken with all stakeholders at the table. Coal mines were supposed to come into compliance with the rule by April, but it's now tied up in legal proceedings in the Eighth Circuit. And obviously, the circuit will decide what the circuit is going to decide. And I hope that they decide that the silica standard is enforceable. But there was also, on July 1, MSHA posted an agenda that really focused on deregulation. Didn't mention the silica standard specifically, but it really focused on the goal of deregulating a lot of aspects of MSHA's work. You indicated that President Trump is pro-worker president. Given your family history, if the court action is resolved in a way that upholds the silica standard, will you do everything you can to protect it so that our miners are protected?
Again, I'm not yet at the department, but if confirmed, I would absolutely commit to helping to ensure that the work of the Office of Policy supports the implementation of that standard.
Thank you. Have you had any discussions with administration officials in preparation for your nomination or discussion about this hearing today about the silica standard in particular?
I have not.
And separately from discussions you might have had with them, is this something that you have followed the development? Because it's a first time ever silica standard. I mean, it'd been probably needed for a long time, but it was sort of a big step forward to finally have one. Had you separately followed that?
At times throughout my career, a silica standard, an OSHA silica standard more than the MSHA silica standard had absolutely crossed my path.
Okay. I appreciate your commitment to try to protect our miners, and with that, Mr. Chair, I yield back.
Thank you. I'll now ask my questions. Mr. Mayor, since the Obama administration, the board has made some pretty severe policy swings, and I gather it's been difficult for workers and other stakeholders to understand and comply with the law. In our personal conversation, you spoke about that complexity. So can you speak to how creating stability and predictability in labor law helps workers? And if confirmed, how would you work to improve compliance with labor law?
Thank you, Senator. The law, wide swings in the law aren't good for anybody. In my opinion, from the standpoint of advising employers, stability is important and understanding the rules of the road are important. As I said in my opening, my experience has been that most employers simply want to treat their employees well and comply with the law. And I truly believe that. Where employers have to change their policies or their handbooks on an occasional basis because the National Labor Relations Board or another agency engages in some adjudication that changes the law is somewhat disruptive. So the goal is stability in the law. And that helps all stakeholders because they really understand all the rules of the road. And that includes not only employers, but all employees and unions.
In our personal conversation, I think either you or Mr. Murphy mentioned how a small, medium-sized business whose workers want to unionize can make a mistake, run afoul of the law just because sometimes the law is counterintuitive. Is there any way to address that? Because, I mean, you want to do the right thing and you get slammed legally because there's a law set up and you're thinking, why in the heck did they do that law? But you only say it after you violated it. Mr. Murphy?
That's correct, Senator. It can happen. Unfortunately, the board can't issue advisory decisions. I do believe that parties could reach out to a regional office and at least get some guidance as far as what they should be doing in a particular situation.
But if you're a small, medium-sized business, I guess you need the attorney to tell you to reach out.
That is a problem. Yes, sir. It's a legal issue and it would probably have to go through legal representation.
And I think you, Mr. Mayor, spoke of the EEOC as having one standard and the NLRB having a different. The first Trump administration tried to reconcile the two, and this is about calling people names. The issue in particular was using racial epithets to call somebody, which clearly should be forbidden by EEOC, but somehow got protected under NLRB, and the employer has to decide which law to break. And I gather that reconciliation under Trump 1 was reversed under Biden. You want to comment on that? Because that just puts the employer aside from the fact that calling racial epithets is wrong?
Well, I'll talk about the current state of the law, Senator, and how it developed, but I can't really speak about issues that could come before me should I be confirmed. This is an issue about whether an employee who's engaged in protected concerted activities has additional protection under the law if those, if the comments or the conduct they're engaging in violates Title VII or some other federal or state law. Prior to the Trump board, there were a number of situation-specific standards that gave additional protections. That was challenged, and in the General Motors case under the Trump board, the EEOC actually weighed in and said, hey, employers shouldn't effectively have to choose which law to break, and issued the General Motors case. That was reversed under the Biden board in a case called Lyon Elastomers.
I would say that's a case history of why don't we give stability of law to work to employers so they can do the right thing by the employees. Just to say. Mr. Palmieri, given your experience in the first Trump administration implementing the Foundations of Evidence-Based Policymaking Act, please describe how you'll incorporate stakeholder feedback in the regulatory process.
Certainly. Thank you, Chairman. I think that was a great work of bipartisanship in the first Trump administration, and I think evidence-based policymaking is truly a bipartisan concern. I think in the regulatory process, we've always had the Administrative Procedure Act to guide us in incorporating stakeholder feedback into our regulatory policies. I think the Evidence-Based Policy Making Act also gives us a chief evidence officer at the Department of Labor, which is in the Office of Policy, to help us ensure that the research work and the data that we're gathering can be utilized in supporting the regulatory policies and choices that we're making. So I look forward to working with you and the committee in furthering those efforts as well.
I'm going to go to another committee hearing. Senator Moody will take the gavel.
Thank you, Senator Cassidy. Happy to do so.
And I'm sorry, I think the way it would go, Markey would go next. I'm sorry, I'm Democrat. I'm sorry.
No, absolutely not. I will take the gavel, and you can go ahead and question.
Thank you, Madam Chair. Mr. Murphy and Mr. Mayor, do you agree with established board precedent that when an employee is fired for either supporting or refusing to support a union, that firing has a chilling effect on other employee speech?
Senator, you're asking me whether an unlawful discharge of an employee in violation of Section 883 of the Act has a chilling effect on the
Just for supporting a union, you get fired?
Yes.
Would that have a chilling effect on other employees' free
It would
speech?
seem to be, and that's why we would have to find a violation and remedy it.
Okay, great. Mr. Mayor, do you agree with that?
Senator, it certainly could. Yes.
It certainly could, or if you just spoke about having a union, should that be grounds for firing?
No, that's protected concerted activity generally.
Well, the NLRB is quite clear on this. If a company fires an employee for exercising their right to organize a union, other workers are discouraged from doing the same. And I ask because President Trump illegally fired board member Gwen Wilcox for, quote, unduly disfavoring the interests of employers. Do you agree that her firing has a chilling effect on your speech as a nominee if confirmed as a board member? Mr. Murphy.
Senator, you're asking me if it has a chilling effect on
Will it? Yeah, will it have a chilling effect on your ability to?
No, Senator. If the Supreme Court ultimately decides that the president has the removal authority that he claims to have, and I will continue to interpret the National Labor Relations Act as I would always have done so. And if this
you will be independent.
The president can then just discharge me.
Mr. Mayor.
I agree with Mr. Murphy.
So it is not possible to truly act independently when you know the president could fire you. That's just the bottom line, if you offend the corporate cronies. If Member Wilcox is not reinstated, the American people cannot trust that you will act impartially rather than favoring CEOs over workers in line with the president's wishes. And as a result, I cannot support your nominations. Mr. Rosario, do you support the president's deregulatory agenda to rescind or weaken over 60 Department of Labor regulations?
Thank you, Senator. Yes.
Yes. And if confirmed at the Department of Labor, how will you decide how many workers are an acceptable number to die on the job if you repeal a safety rule?
No number of workers is an acceptable number of deaths, sir.
Yeah, well, you know, there was no OSHA when my father was a boy, and his finger got chopped off in a factory, and the boss just said to him, see you on Monday in the factory, John. No OSHA, no protections. That's the way it used to be before we put regulations on the books. Of course, my father used a different finger to describe the bosses at the kitchen table at night to me and my brothers. So 5,000 workers die on the job every single year in our country. Do you support the president's deregulatory agenda to repeal rules that ensure workers make it home at the end of their shift, Mr. Palmieri?
I believe that the president's deregulatory agenda and the items that you mentioned are intended to promote additional flexibility, potentially to remove outdated requirements that no longer reflect the modern workplace and are not designed to reduce the safety of workplaces in any way.
Well, right now, the Secretary of Labor is trying to weaken mine safety plans, lower respirator standards for workers exposed to harmful chemicals, and stop requiring construction sites from having any lights. So my question to you, again, Mr. Palmieri, is if you are part of repealing a rule that leads to the death of a worker who is killed in a mine or gets lung cancer or falls down a work site into the dark, do you commit to calling their families and offering their condolences?
I don't believe that any of the policies of this administration would lead to the deaths of workers, but I share your concern and would absolutely have compassion for any family member of anyone who died as a result of a workplace accident.
Well, Mr. Mayor, I would just like to close by sharing my deep concern about your ability to fairly rule on matters of union busting. You serve as the Chief Labor Counsel at Boeing, a notorious union buster. Boeing has and continues to adjust its flight path from a heavily unionized, safety-first company to a union-busting Wall Street pleasing corporation with a tattered safety record. And you and your friends at Boeing have prioritized soaring profits over safe planes. Your workers paid the price, and the traveling public has paid the price. And it's why I have introduced my Safety Starts at the Top Act, which would require companies like Boeing to have representatives from labor and from safety experts on their board of directors. So I thank you, Madam Chair, and I yield back.
I believe Senator Murkowski is going to take over as chair. Thank you. Rightfully passed, and now I will begin questioning. Thank you for being here today. Thank you for offering your professional careers to service of your country. And thank you to all your family members that are here with you today. I know that Senate nomination hearings are sometimes not fun, but I hope that you are incredibly proud of your family members that are sitting here and answering questions. They're not easy questions all the time, but we are asking them to take on very, very important roles, and we're certainly glad for their service and the families that support them. So thank you so much. One of the things that has troubled me deeply over the last few years is that we haven't had a functioning, efficiently, well, I should say efficiently or functioning at all, NLRB. And so I think it's incredibly important that we're moving in that direction. There's a huge decision backlog right now. I think in 1 year from 23 to 24, we went up 46% in the backlog, which is not good for the American worker and certainly not good for President Trump's America First agenda and supporting workers. And I am hopeful that this hearing today gets us one step closer to an efficient NLRB. And that said, we'll turn to some nominees here. I'll begin with Mr. Murphy. I'm incredibly concerned, as I said, about productivity and decision delays at the board. I note 47 years of experience. Under your previous leadership, you had reduced number of cases and the median age of cases pending by more than 50%. I'm told that you have publicly said one of the reasons you want to do this is to help with the backlog. I'm a former judge and had a firm belief that efficiency of courts, and obviously it's a different body, but efficiency has just as much to do with having a successful process as does the substantive work. Both are equally important. And if one does not exist, it is like you are not offering any type of justice or resolution to complaints. And so I am grateful to you for coming out of retirement, not just for serving, but for saying, I'll keep doing this in order to right a wrong. I truly believe it's a wrong to have such a backlog of cases. Can you give us a little bit more background as to why you think there is such a tremendous backlog that occurred, especially during the last few years? And then what are some of your proposed efficiency improvements that you believe you could bring to the role?
Thank you, Senator. We discussed this a little bit earlier prior to your arrival, but there are multiple reasons, I think, for the backlog. The most recent one, obviously, being the lack of a quorum since January of this year. Prior to that, though, there was a substantial increase of unfair labor practice charges filed in the regional offices, and even though 95% of cases are generally resolved before they ever get to the National Labor Relations Board in Washington, that still increased the number of cases in Washington to an unacceptable amount. It's above 500 cases in pending backlog. What we can do is, as I talked earlier about, hopefully with a restored board quorum, we can address cases quickly. The low-hanging fruit, there are any number of cases out there that can be resolved unanimously by a 3-member panel without any partisan disagreements. Beyond that, I would hope to be able to address as many cases as possible, focusing on the oldest cases, because in some egregious situations, they've been pending for as much as 4 years. The personnel is there. I mean, at the agency, we've got very, very good people, but they have to have the direction, the common direction of the board, from the board members as to which cases to address, and they will commit, I guarantee you they will commit to handling them as quickly as possible.
And how quickly do you think you'll be able to, the board will be able to start making progress on that backlog?
I'd like to start on day one, but that's a little bit ambitious, but believe me, would be my primary objective. Now, I'm just one of 3 board members, but it would be my primary objective.
Any thoughts, Mr. Mayor?
Thank you, Senator. 2 thoughts. First of all, I've never been on the board side. I've never worked for the board, so it's kind of a black hole for me. I'd be relying on both, if I'm confirmed, both Mr. Murphy and Mr. Prouty for guidance and working together to clear out the backlog. I believe that is very important. The other thing I'll just note for you is, I think one of the issues for the backlog, that a lot of cases over the last few years that could have settled hadn't settled because the environment and in the regions was not conducive to settlement. Acting General Counsel Cowan, when he arrived, issued a number of memos, one of which encouraged settlement and removed some of the barriers to settlement. So I'm hoping that will also help clear out the backlog.
Thank you.
Thank you, Senator Moody. Gentlemen, thank you for appearing before the committee this morning and your willingness to serve within this administration, all very important positions. I know that prior to my arrival here, several of my colleagues have raised the issue of independence within, well, independence within the NLRB and how important that is. It's my understanding that in your presentations before the Health Committee staff, you reiterated your view that that the NLRB is truly designed and meant to be that independent agency. I would just ask for you to commit to me in this open hearing your commitment to enforce the National Labor Relations Act fairly, regardless of employer or union affiliation. Mr. Murphy?
I can easily make that commitment, Senator. That would be the only reason I would be at the National Labor Relations Board.
Very good, thank you, I appreciate that. Mr. Mayor?
Yes, Senator, I commit to, if I'm confirmed, I commit to enforcing the law fairly and impartially.
Very good, I appreciate that. We have some unique challenges when it comes to the Alaska workforce. A great deal of seasonality, whether it is within our fisheries industry, whether it's in our construction, our trades. It is an issue that is not unique to us, but maybe it's just a little more enhanced in the state. And so I put that before you as an issue that we pay attention to in making sure that seasonal and contract workers are also properly protected under the NLRA. Another issue that comes up in my state, perhaps more so than in others, is the relationship with tribes. We have half of all of the tribes in the country that are situated in Alaska. We have a number of tribes, and our Alaska Native corporations operate both public and private sector enterprises. And so it creates an interesting situation as you deal with questions of labor law relating to sovereign entities and some oftentimes complex jurisdictional issues. I don't expect either one of you to have the answer as to how you're going to navigate that, but I want to put it on your radar that these may occupy some of your time in recognizing that it's just a little different in how we navigate some of these issues. So if you can, again, just give me a commitment that you will be paying attention to them and recognizing the significance on a state like Alaska that is oftentimes somewhat unique in regards to these considerations with our workforce.
I can certainly understand how significant that is in Alaska. It's probably also very significant in the state of Oklahoma. Currently, there is pending a Tribal Reservation Act, I believe, before Congress, so I can't speak to the merits of that. Under a board case dating 10 to 15 years ago, San Manuel Bingo, the board asserted jurisdiction over tribal employers, both on and off the reservations, and to the extent that cases, and I've seen very few cases, I've been out of the board for 3 years, but very few cases in recent years involving tribal employers. But if the Congress wishes to revisit that issue, I can perfectly understand it because there's concerns about tribal governance as far as intruding on tribal governments, and we certainly, the board itself has said that it can't make any decision that would intrude upon a treaty.
Very good, very good. Mr. Palmieri, let me turn to you for a moment here. I'm going to take it back to the issue that I just raised about our seafood, our fishing industry. The H-2B program is really very vital to the industry. Historically, our seafood processors have relied on H-2B workers to fill these workforce gaps. You're working in areas that you're not part of a community. You are out in the middle of absolutely nowhere. Oftentimes, you don't have amenities like internet. It is tough to find workers, and believe me, the industry bends over backwards to make sure that we can find every American who is willing to come out to these areas. And it's not necessarily pretty work. It's wet and it's slimy, and it's how we get our seafood to America. And we're very proud of it. But we do have a challenge. and have for some years. The H-2B program is oversubscribed. The processors depend on supplemental visas being issued for the pollock and the cod season that's coming up on us. I again, am raising this to you as an issue, but I would just hope that you would support issuing supplemental H-2Bs to the maximum extent that's authorized by law. And it's not just a question of, or a matter of moving forward with the supplementals, but doing so in a timely manner. Because we've got seasons that don't necessarily mesh with anybody else's, causing us to be left behind when it comes to available visas. So should you be confirmed, I would hope that this is something that you would commit to working with us on, as well as the folks over at Department of Homeland Security, because it's a dual approval process. So what is already complicated has now become more complicated. So I don't know if you have any familiarity with it and you choose to comment now, or just give me your commitment.
I'd just say that certainly in the first Trump administration, when I served in OMB, a range of these issues had certainly come before me and come to my attention. And I know that the president cares deeply about issues related to fisheries, fishermen, lobstermen, critically important careers, as well as the other seasonal labor that's so critical to Alaska. So I absolutely commit to work with you and your team on any of these issues, should they come before me if confirmed.
Well, thank you for that. We had a very constructive seafood summit between the Alaska delegation, some folks within the seafood industry, and Secretary Lutnick, Secretary Rollins, and Dr. Kevin Hassett. It was really gratifying to hear their commitment to resolving many of these issues. And so I think you're right. I think the administration has taken a forward-leaning approach to it. Secretary Rollins, in my view, it was music to my ears to hear her say that fishermen are truly our farmers of the sea. And it's an important industry for our country. Last question for you. And since there's nobody here and my time has expired, but I can ignore the red on the panel here, I want to ask about apprenticeship opportunities in some very rural areas. As you know, in keeping with the President's executive order for Alaska on releasing our extraordinary potential for everything in the energy sector and beyond, our challenge is our workforce. We're a small population, and building that capable workforce is hard. It's a challenge that we accept, but providing appropriate training for those in the rural and the remote areas still remains a significant challenge. Because what happens is we've got apprenticeship programs, and it's super, but they're typically centralized in more populated areas. And when you come from a state where 80% of your communities are not connected by a road, it's just a challenge to get there. It's an expense to get there. You can't bring your family necessarily with you. And so it really is a very significant barrier. We have been trying to be creative in working with those in the everyone from the trades and the unions, the workforce development programs, but I would just ask for your willingness to work with me on finding some creative ways to support workforce development in our rural areas where, again, communities are off the road system, they're disconnected from some of the traditional workforce. And when I say creative, one of the things that has come to my attention is if there was just childcare that I could get assistance with so that I could leave my community for the several-week period. And typically we don't think about apprenticeships and providing childcare, but we've got to figure out ways to break down the barrier. So I would just ask for your help and your support on that.
Thank you, Senator. Had an opportunity to visit with some of your staff earlier in this process, and so I think we know the unique challenges that Alaska faces. And again, I feel like from the first Trump administration to this, Alaska has always had sort of a special place in the administration's heart and thinking. And especially in front of all of your colleagues, I think we can say Alaska is obviously one of the best and most important states.
You got it.
When addressing any and all policies. So I'd just say, I think I can speak freely and say that the unique challenges facing Alaska will be top of mind across the range of issues and industries that are important to the state, and that we commit to work with you and your team to be able to think through some of these creative opportunities to achieve the American workforce we want and the Alaskan workforce we want.
Appreciate that. Gentlemen, thank you for your time this morning, and to your families, thank you as well for being here. For any senator wishing to ask additional questions for the record will be due tomorrow at 5 p.m. on Thursday, October 2nd. So again, thank you all. The committee stands adjourned.